This is the implementing rules of Book 3, of the Labor Code of the Philippines. Book 3, Conditions of Employment. Rule 1. Hours of work. Section 1. General Statement on Coverage. The provisions of this rule shall apply to all employees in all establishments and undertakings, whether operated for profit or not, except to those specifically exempted under Section 2 hereof. Section 2. Exemption. The provisions of this rule shall not apply to the following persons, if they qualify for exemption under the conditions set forth herein. A. Government employees, whether employed by the national government or any of its political subdivisions, including those employed in government-owned and/or controlled corporations. B. Managerial employees, if they meet all of the following conditions, namely: 1. Their primary duty consists of the management of the establishment in which they are employed, or of a department or subdivision thereof. 2. They customarily and regularly direct the work of 2 or more employees therein. 3. They have the authority to hire or fire other employees of lower rank, or their suggestions and recommendations as to the hiring and firing, and as to the promotion or any other change of status of other employees, are given particular weight. C. Officers or members of a managerial staff, if they perform the following duties and responsibilities. 1. The primary duty consists of the performance of work directly related to management policies of their employer. 2. Customarily and regularly exercise discretion and independent judgment. 3. Regularly and directly assist a proprietor, or a managerial employee whose primary duty consists of the management of the establishment, in which he is employed, or subdivision thereof. Or execute under general supervision, work along specialized or technical lines requiring special training, experience, or knowledge. Or execute under general supervision special assignments and tasks. And 4. Who do not devote more than 20% of their hours worked in a workweek, to activities which are not directly and closely related to the performance of the work described in paragraphs 1, 2, and 3 above. D. Domestic servants and persons in the personal service of another, if they perform such services in the employer's home, which are usually necessary or desirable for the maintenance and enjoyment thereof, or minister to the personal comfort, convenience, or safety of the employer, as well as the members of his employer's household. E. Workers who are paid by results, including those who are paid on piecework, tuck-eye, puck-cow, or task basis, if their output rates are in accordance with the standards prescribed under Section 8, Rule 7, Book 3, of these regulations, or where such rates have been fixed by the Secretary of Labor in accordance with the aforesaid section. F. Non-agricultural field personnel, if they regularly perform their duties away from the principal or branch office, or place of business of the employer, and whose actual hours of work in the field cannot be determined with reasonable certainty. Section 3. Hours worked. The following shall be considered as compensable hours worked. A. All time during which an employee is required to be on duty, or to be at the employer's premises, or to be at a prescribed workplace. And B. All time during which an employee is suffered or permitted to work. Section 4. Principles in determining hours worked. The following general principles shall govern in determining whether the time spent by an employee is considered hours worked for purposes of this rule. A. All hours are hours worked, which the employee is required to give to his employer, regardless of whether or not such hours are spent in productive labor, or involve physical or mental exertion. B. An employee need not leave the premises of the workplace in order that his rest period shall not be counted, it being enough that he stops working, may rest completely and may leave his workplace, to go elsewhere, whether within or outside the premises of his workplace. C. If the work performed was necessary, or it benefited the employer, or the employee could not abandon his work at the end of his normal working hours because he had no replacement, all time spent for such work, shall be considered as hours worked, if the work was with the knowledge of his employer or immediate supervisor. D. The time during which an employee is inactive, by reason of interruptions in his work beyond his control, shall be considered time either if the imminence of the resumption of work, requires the employee's presence at the place of work, or if the interval is too brief to be utilized effectively and gainfully in the employee's own interest. Section 5. Waiting time. A. Waiting time spent by an employee, shall be considered as working time, if waiting is an integral part of his work, or the employee is required or engaged by the employer to wait. B. An employee who is required to remain on call, in the employer's premises or so close thereto, that he cannot use the time effectively and gainfully for his own purpose, shall be considered as working while on call. An employee who is not required to leave word at his home or with company officials, where he may be reached is not working while on call. Section 6. Lectures, meetings, training programs. Attendance at lectures, meetings, training programs, and other similar activities, shall not be counted as working time, if all of the following conditions are met. A. Attendance is outside of the employee's regular working hours. B. Attendance is in fact voluntary. And C. The employee does not perform any productive work during such attendance. Section 7. Meal and rest periods. Every employer shall give his employees, regardless of sex, not less than 1 hour time off for regular meals, except in the following cases when a meal period of not less than 20 minutes may be given by the employer, provided that such shorter meal period is credited as compensable hours worked of the employee. A. Where the work is non-manual work in nature, or does not involve strenuous physical exertion. B. Where the establishment regularly operates not less than 16 hours a day. C. In cases of actual or impending emergencies, or there is urgent work to be performed on machineries, equipment or installations to avoid serious loss which the employer would otherwise suffer. And D. Where the work is necessary to prevent serious loss of perishable goods. Rest periods, or coffee breaks running from 5 to 20 minutes, shall be considered as compensable working time. Section 8. Overtime pay. An employee covered by this rule, who is permitted or required to work beyond 8 hours on ordinary working days, shall be paid an additional compensation for the overtime work, in an amount equivalent to his regular wage plus at least 25% thereof. Section 9. Premium and overtime pay for holiday and rest day work. A. Except employees referred to under Section 2 of this rule, an employee who is permitted or suffered to work on special holidays, or on his designated rest days not falling on regular holidays, shall be paid with an additional compensation, as premium pay of not less than 30% of his regular wage. For work performed in excess of 8 hours on special holidays, and rest days not falling on regular holidays, an employee shall be paid an additional compensation for the overtime work, equivalent to his rate for the first 8 hours on a special holiday or rest day plus at least 30% thereof. B. Employees of public utility enterprises, as well as those employed in nonprofit institutions and organizations, shall be entitled to the premium and overtime pay provided herein, unless they are specifically excluded from the coverage of this rule, as provided in Section 2 hereof. C. The payment of additional compensation for work performed on regular holidays, shall be governed by Rule 4, Book 3, of these rules. Section 10. Compulsory overtime work. In any of the following cases, an employer may require any of his employees to work beyond 8 hours a day, provided that the employee required to render overtime work, is paid the additional compensation required by these regulations. A. When the country is at war, or when any other national or local emergency, has been declared by the National Assembly or the Chief Executive. B. When overtime work is necessary, to prevent loss of life or property, or in case of imminent danger to public safety, due to actual or impending emergency in the locality caused by serious accident, fire, floods, typhoons, earthquake, epidemic or other disaster or calamities. C. When there is urgent work to be performed on machines, installations, or equipment, or in order to avoid serious loss or damage to the employer, or some other causes of similar nature. D. When the work is necessary, to prevent loss or damage to perishable goods. E. When the completion or continuation of work started before the 8th hour, is necessary to prevent serious obstruction, or prejudice to the business or operations of the employer. F. When overtime work is necessary to avail of favorable weather or environmental conditions, where performance or quality of work is dependent thereon. In cases not falling within any of these enumerated in this section, no employee may be made to work beyond 8 hours a day against his will. Section 11. Computation of additional compensation. For purposes of computing the additional compensation required by this rule, the regular wage, of an employee, shall include the cash wage only, without deduction on account of facilities provided by the employer. Rule 1-A. Hours of work of hospital and clinic personnel. Section 1. General Statement on Coverage. This rule shall apply to A. All hospitals and clinics, including those with a bed capacity of less than 100, which are situated in cities or municipalities with a population of 1 million or more. And B. All hospitals and clinics with a bed capacity of at least 100, irrespective of the size of the population of the city or municipality where they may be situated. Section 2. Hospitals or clinics within the meaning of this rule. The terms hospitals, and clinic, as used in this rule, shall mean a place devoted primarily to the maintenance, and operation of facilities for the diagnosis, treatment and care of individuals suffering from illness, disease, injury, or deformity, or in need of obstetrical or other medical and nursing care. Either term, shall also be construed as any institution, building, or place, where there are installed beds, or cribs, or bassinets for 24 hours use, or longer by patients in the treatment of diseases, injuries, deformities, or abnormal physical and mental states, maternity cases or sanatorial care. Or infirmaries, nurseries, dispensaries, and such other similar names by which they may be designated. Section 3. Determination of bed capacity and population. A. For purposes of determining the applicability of this rule, the actual bed capacity of the hospital or clinic, at the time of such determination shall be considered, regardless of the actual or bed occupancy. The bed capacity of hospital or clinic, as determined by the Bureau of Medical Services, pursuant to Republic Act No. 4226, otherwise known as the Hospital Licensure Act, shall prima facie be considered as the actual bed capacity of such hospital or clinic. B. The size of the population of the city or municipality, shall be determined, from the latest official census issued by the Bureau of the Census and Statistics. Section 4. Personnel covered by this rule. This rule applies to all persons employed by any private or public hospital or clinic mentioned in Section 1 hereof, and shall include, but not be limited to, resident physicians, nurses, nutritionists, dietitians, pharmacists, social workers, laboratory technicians, paramedical technicians, psychologists, midwives, and attendance. Section 5. Regular working hours. The regular working hours of any person covered by this rule, shall not be more than 8 hours in any one day, nor more than 40 hours in any one week. For purposes of this rule, a day, shall mean a workday of 24 consecutive hours, beginning at the same time each calendar day. A week, shall mean the work week of 168 consecutive hours, or 7 consecutive 24-hour workday, beginning at the same hour and on the same calendar day each calendar week. Section 6. Regular working days. The regular working days of covered employees, shall not be more than 5 days in a work week. The work week may begin at any hour and on any day, including Saturday or Sunday, designated by the employer. Employers are not precluded from changing the time at which the workday or work week begins, provided that the change is not intended to evade the requirements of this rule. Section 7. Overtime work. Where the exigencies of the service so require, as determined by the employer, any employee covered by this rule may be scheduled to work for more than 5 days or 40 hours a week, provided that the employee is paid for the overtime work, an additional compensation equivalent to his regular wage plus at least 30% thereof, subject to the provisions of this book on the payment of additional compensation, for work performed on special and regular holidays, and on rest days. Section 8. Hours worked. In determining the compensable hours of work, of hospital and clinic personnel covered by this rule, the pertinent provisions of Rule 1 of this book shall apply. Section 9. Additional compensation. Hospital and clinic personnel covered by this rule, with the exception of those employed by the government, shall be entitled to an additional compensation, for work performed on regular and special holidays and rest days, as provided in this book. Such employees, shall also be entitled to overtime pay, for services rendered in excess of 40 hours a week, or in excess of 8 hours a day, whichever will yield the higher additional compensation to the employee in the work week. Section 10. Relation to Rule 1. All provisions of Rule 1 of this book, which are not inconsistent with this rule, shall be deemed applicable to hospital and clinic personnel. Rule 2. Night shift differential. Section 1. Coverage. This rule shall apply to all employees, except A. Those of the government and any of its political subdivisions, including government-owned and/or controlled corporations. B. Those of retail and service establishments, regularly employing not more than 5 workers. C. Domestic helpers and persons in the personal service of another. D. Managerial employees as defined in Book 3 of this Code. E. Field personnel, and other employees whose time and performance is unsupervised by the employer, including those who are engaged on task or contract basis, purely commission basis, or those who are paid a fixed amount for performing work irrespective of the time consumed in the performance thereof. Section 2. Night shift differential. An employee shall be paid night shift differential, of no less than 10% of his regular wage, for each hour of work, performed between 10 o'clock in the evening and 6 o'clock in the morning. Section 3. Additional compensation. Where an employee is required or suffered to work, on the period covered after his work schedule, he shall be entitled to his regular wage plus at least 25%, and an additional amount of no less than 10% of such overtime rate, for each hour of work performed between 10 p.m. to 6 a.m. Section 4. Additional compensation on scheduled rest day or special holiday. An employee who is required or permitted to work, on the period covered during rest days and/or special holidays not falling on regular holidays, shall be paid a compensation, equivalent to his regular wage plus at least 30%, and an additional amount of not less than 10% of such premium pay rate for each hour of work performed. Section 5. Additional compensation on regular holidays. For work on the period covered during regular holidays, an employee shall be entitled to his regular wage during these days, plus an additional compensation of no less than 10% of such premium rate for each hour of work performed. Section 6. Relation to agreements. Nothing in this rule shall justify an employer in withdrawing or reducing any benefits, supplements or payments as provided in existing individual or collective agreements, or employer practice or policy. Rule 3. Weekly rest periods. Section 1. General statement on coverage. This rule shall apply to all employers whether operating for profit or not, including public utilities operated by private persons. Section 2. Business on Sundays or holidays. All establishments and enterprises may operate or open for business on Sundays and holidays, provided that the employees are given the weekly rest day and the benefits as provided in this rule. Section 3. Weekly rest day. Every employer shall give his employees a rest period of not less than 24 consecutive hours, after every 6 consecutive normal work days. Section 4. Preference of employee. The preference of the employee, as to his weekly day of rest, shall be respected by the employer, if the same is based on religious grounds. The employee shall make known his preference to the employer in writing at least 7 days before the desired effectivity of the initial rest day so preferred. Where, however, the choice of the employees as to their rest day based on religious grounds will inevitably result in serious prejudice or obstruction to the operations of the undertaking, and the employer cannot normally be expected to resort to other remedial measures, the employer may so schedule the weekly rest day of their choice, for at least 2 days in a month. Section 5. Schedule of rest day. A. Where the weekly rest is given to all employees simultaneously, the employer shall make known such rest period, by means of a written notice posted conspicuously in the workplace, at least 1 week before it becomes effective. B. Where the rest period is not granted to all employees simultaneously and collectively, the employer shall make known to the employees their respective schedules of weekly rest through written notices posted conspicuously in the workplace, at least 1 week before they become effective. Section 6. When work on rest day authorized. An employer may require any of his employees to work on his scheduled rest day, for the duration of the following emergency and exceptional conditions. A. In case of actual or impending emergencies caused by serious accident, fire, flood, typhoon, earthquake, epidemic or other disaster or calamity, to prevent loss of life or property, or in cases of force majeure or imminent danger to public safety. B. In case of urgent work to be performed on machineries, equipment or installations, to avoid serious loss, which the employer would otherwise suffer. C. In the event of abnormal pressure of work due to special circumstances, where the employer cannot ordinarily be expected to resort to other measures. D. To prevent serious loss of perishable goods. E. Where the nature of the work is such that the employees have to work continuously for 7 days in a week or more, as in the case of the crew members of a vessel to complete a voyage, and in other similar cases. And F. When the work is necessary to avail of favorable weather or environmental conditions, where performance or quality of work is dependent thereon. No employee shall be required against his will to work on his scheduled rest day, except under circumstances provided in this section. Provided, however, that where an employee volunteers to work on his rest day under other circumstances, he shall express such desire in writing, subject to the provisions of Section 7 hereof regarding additional compensation. Section 7. Compensation on rest day, Sunday or holiday. A. except those employees referred to under Section 2, Rule 1, Book 3, an employee who is made or permitted to work on his scheduled rest day, shall be paid with an additional compensation of at least 30% of his regular wage. An employee shall be entitled to such additional compensation for work performed on a Sunday, only when it is his established rest day. B. Where the nature of the work of the employee is such that he has no regular work days, and no regular rest days can be scheduled, he shall be paid an additional compensation of at least 30% of his regular wage for work performed on Sundays and holidays. C. Work performed on any special holiday shall be paid with an additional compensation of at least 30% of the regular wage of the employee. Where such holiday work falls on the employee's scheduled rest day, he shall be entitled to additional compensation of at least 50% of his regular wage. D. The payment of additional compensation for work performed on regular holiday shall be governed by the Rule 4, Book 3 of these regulations. E. Where the collective bargaining agreement, or other applicable employment contract, stipulates the payment of a higher premium pay than that prescribed under this section, the employer shall pay such higher rate. Section 8. Paid off days. Nothing in this rule shall justify an employer, in reducing the compensation of his employees for the unworked Sundays, holidays, or other rest days, which are considered paid off days or holidays by agreement or practice subsisting upon the effectivity of the Code. Section 9. Relation to agreement. Nothing herein shall prevent the employer and his employees or their representatives from entering into any agreement, with terms more favorable to the employees than those provided herein, or be used to diminish any benefit granted to the employees under existing laws, agreements, and voluntary employer practices. Rule 4. Holidays with pay. Section 1. Coverage. This rule shall apply to all employees except A. Those of the government and any of the political subdivisions, including government-owned and controlled corporation. B. Those of retail and service establishments regularly employing less than 10 workers. C. Domestic helpers and persons in the personal service of another. D. Managerial employees as defined in Book 3 of the Code. E. Field personnel, and other employees whose time and performance is unsupervised by the employer, including those who are engaged on task or contract basis, purely commission basis, or those who are paid a fixed amount for performing work irrespective of the time consumed in the performance thereof. Section 2. Status of employees paid by the month. Employees who are uniformly paid by the month, irrespective of the number of working days therein, with a salary of not less than the statutory or established minimum wage, shall be presumed to be paid for all days in the month whether worked or not. For this purpose, the monthly minimum wage shall not be less than the statutory minimum wage, multiplied by 365 days, divided by 12. Section 3. Holiday pay. Every employer shall pay his employees their regular daily wage for any unworked regular holiday. As used in the rule, the term holiday shall exclusively refer to New Year's Day, Maundy Thursday, Good Friday, the 9th of April, the 1st of May, the 12th of June, the 4th of July, the 30th of November, the 25th and 30th of December, and the day designated by law for a general election, or national referendum or plebiscite. Section 4. Compensation for holiday work. Any employee who is permitted or suffered to work on any regular holiday, not exceeding 8 hours, shall be paid at least 200% of his regular daily wage. If the holiday work falls on the scheduled rest day of the employee, he shall be entitled to an additional premium pay of at least 30% of his regular holiday rate of 200% based on his regular wage rate. Section 5. Overtime pay for holiday work. For work performed in excess of 8 hours on a regular holiday, an employee shall be paid an additional compensation, for the overtime work equivalent to his rate for the first 8 hours on such holiday work, plus at least 30% thereof. Where the regular holiday work exceeding 8 hours, falls on the scheduled rest day of the employee, he shall be paid an additional compensation for the overtime work, equivalent to his regular holiday rest day for the first 8 hours plus 30% thereof. The regular holiday rest day rate of an employee, shall consist of 200% of his regular wage rate plus 30% thereof. Section 6. Absences. A. All covered employees, shall be entitled to the benefit provided herein when they are on leave of absence with pay. Employees who are on leave of absence without pay, on the day immediately preceding a regular holiday, may not be paid the required holiday pay, if he has not worked on such regular holiday. B. Employees shall grant the same percentage of the holiday pay, as the benefit granted by competent authority, in the form of employees' compensation or Social Security payment, whichever is higher, if they are not reporting for work while on such benefits. C. Where the day immediately preceding the holiday, is a non-working day in the establishment, or the scheduled rest day of the employee, he shall not be deemed to be on leave of absence on that day, in which case he shall be entitled to the holiday pay, if he worked on the day immediately preceding the non-working day or rest day. Section 7. Temporary or periodic shutdown, and temporary cessation of work. A. In cases of temporary or periodic shutdown, and temporary cessation of work of an establishment, as when a yearly inventory, or when the repair or cleaning of machineries and equipment is undertaken, the regular holidays falling within the period, shall be compensated in accordance with this rule. B. The regular holiday during the cessation of operation of an enterprise, due to business reverses as authorized by the Secretary of Labor, may not be paid by the employer. Section 8. Holiday pay of certain employees. A. Private school teachers, including faculty members of colleges and universities, may not be paid for the regular holidays during semestral vacations. They shall, however, be paid for the regular holidays during Christmas vacation. B. Where a covered employee is paid by results or output, such as payment on piecework, his holiday pay, shall not be less than his average daily earnings for the last 7 actual working days preceding the regular holiday. Provided, however, that in no case shall the holiday pay be less than the applicable statutory minimum wage rate. C. Seasonal workers may not be paid the required holiday pay during off-season, where they are not at work. D. Workers who have no regular working days, shall be entitled to the benefits provided in this rule. Section 9. Regular holiday falling on rest days or Sundays. A. A regular holiday falling on the employee's rest day, shall be compensated accordingly. B. Where a regular holiday falls on a Sunday, the following day shall be considered a special holiday for purposes of the Labor Code, unless said day is also a regular holiday. Please note that this rule is rendered obsolete by Letter of Instruction No. 1087, issued on November 26, 1980, which in part states, when a legal holiday falls on a Sunday, the following Monday shall not be a holiday, unless a proclamation is issued declaring it a special holiday. Section 10. Successive regular holidays. Where there are 2 successive regular holidays, like Holy Thursday and Good Friday, an employee may not be paid for both holidays, if he absents himself from work, on the day immediately preceding the first holiday, unless he works on the first holiday, in which case he is entitled to his holiday pay on the second holiday. Section 11. Relation to agreements. Nothing in this rule shall justify an employer, in withdrawing or reducing any benefits, supplements or payments for unworked holidays, as provided in existing individual or collective agreement, or employer practice or policy. Rule 5. Service incentive leave. Section 1. Coverage. This rule shall apply to all employees except A. Those of the government and any of its political subdivisions, including government-owned and controlled corporations. B. Domestic helpers and persons in the personal service of another. C. Managerial employees as defined in Book 3 of this Code. D. Field personnel and other employees whose performance is unsupervised by the employer, including those who are engaged on task or contract basis, purely commission basis, or those who are paid in a fixed amount for performing work irrespective of the time consumed in the performance thereof. E. Those who are already enjoying the benefit herein provided. F. Those enjoying vacation leave with pay of at least 5 days. And G. Those employed in establishments, regularly employing less than 10 employees. Section 2. Right to service incentive leave. Every employee who has rendered at least 1 year of service, shall be entitled to a yearly service incentive leave of 5 days with pay. Section 3. Definition of certain terms. The term, at least 1 year service, shall mean service within 12 months, whether continuous or broken, reckoned from the date the employee started working, including authorized absences and paid regular holidays, unless the working days in the establishment as a matter of practice or policy, or that provided in the employment contract, is less than 12 months, in which case said period shall be considered as 1 year. Section 4. Accrual of benefit. Entitlement to the benefit provided in this rule, shall start December 16, 1975, the date the amendatory provision of the Code took effect. Section 5. Treatment of benefit. The service incentive leave, shall be commutable to its money equivalent if not used or exhausted at the end of the year. Section 6. Relation to agreements. Nothing in the rule, shall justify an employer from withdrawing or reducing any benefits, supplements or payments provided in existing individual or collective agreements, or employers' practices or policies. Rule 6. Service charges. This has been amended by Department Order No. 206. Series of 2019. Section 1. Coverage. This rule, shall apply to all establishments collecting service charges, such as hotels, restaurants, and other similar establishments, including those entities operating primarily as private subsidiaries of the government. Section 2. Definition of terms. As used in this rule, the following terms are defined as follows. A. Covered employees, refer to all employees, except managerial employees as defined herein, under the direct employ of the covered establishment, regardless of their positions, designations or employment status, and irrespective of the method by which their wages are paid. B. Covered establishments, refer to those that collect service charge for work or service they offer. C. Managerial employees. Refer to any person vested with powers or prerogatives to lay down and execute management policies, or hire, transfer, suspend, lay off, recall, discharge, assign or discipline employees, or to effectively recommend such managerial actions. D. Other similar establishments, refer to those entities that collect service charge for work or service rendered, such as, but not limited to, lodging houses, night clubs, cocktail lounges, massage clinics, bars, casinos and gambling houses, and sports clubs. E. Service charge. Refers to the amount, that is added to the bill for work or service rendered. Section 3. Distribution of service charges. All service charges actually collected by covered establishments, shall be distributed completely and equally, based on actual hours or days of work, or service rendered, among the covered employees, including those already receiving the benefit of sharing in the service charges. Section 4. Frequency of distribution. The shares referred to herein, shall be distributed and paid to the covered employees, not less than once every 2 weeks or twice a month, at intervals not exceeding 16 days. Section 5. Increase in minimum wage. In the event that the minimum is increased by law or wage order, service charges paid to the covered employees, shall not be considered in determining the covered establishment's compliance with the increased minimum wage. Section 6. Dispute resolution. Any dispute, or difference on the distribution of service charges, shall be settled through the grievance machinery, as provided in the collective bargaining agreement or CBA. In unorganized establishments, where no grievance mechanism is established, or the grievance mechanism is inadequate, the grievance shall be referred to the Dole Regional Office, which has jurisdiction over the workplace for conciliation. Unresolved grievances shall be resolved in accordance with existing rules and regulations on the visitorial and enforcement power of the Secretary of Labor and Employment, and his or her duly authorized representatives. Rule 7. Wages. Section 1. Minimum wages. A. The minimum wage rates for agricultural and non-agricultural employees shall be as follows, unless otherwise revised by a duly issued wage order, or other authoritative issuance by a competent authority. 1. 8 pesos a day for non-agricultural workers. 2. 4 pesos and 75 centavos for agricultural employees. 3. 6 pesos a day for employees of retail or service enterprises, that do not regularly employ more than 5 employees. 4. 8 pesos a day for employees of the national government, and all government-owned and or controlled corporations. 5. 5 pesos a day for employees of provinces, municipalities and cities, or the minimum wages being paid to them at the time of the approval of IRR No. 6129 on June 17, 1970. The minimum wage rates in industries prescribed by duly issued wage orders, shall remain effective, unless otherwise revised by competent authority. B. The basis of the minimum wage rates prescribed herein, is understood to be not more than 8 hours of work in a day. Section 2. Minimum wages in depressed areas. To the extent necessary to relieve serious unemployment situation in welfare areas, such as squatter relocation centers, the Secretary of Labor may, on his own initiative, or upon petition of any interested party, authorize the payment of subminimum wages, by enterprises and institutions that may be established in such areas, to provide employment opportunities to the residents therein. The authorization of the Secretary of Labor, shall be subject to such terms and conditions as he may prescribe, to ensure the protection and welfare of the workers, as well as the industries that may be affected thereby. Section 3. Coverage. This rule shall not apply to the following persons. A. Household or domestic helpers, including family drivers and persons in the personal service of another. B. Homeworkers engaged in needlework. C. Workers employed in any establishment duly registered with the National Cottage Industries and Development Authority, in accordance with IRR No. 3470. Provided that such workers perform the work in their respective homes. D. Workers in any duly registered cooperative, when so recommended by the Bureau of Cooperative Development, and upon approval of the Secretary of Labor. Provided, however, that such recommendation shall be given only for the purpose of making the cooperative viable, and upon finding and certification of said Bureau, supported by adequate proof, that the cooperative cannot resort to other remedial measures without serious loss or prejudice to its operation, except through its exemption from the requirements of this rule. The exemption shall be subject to such terms and conditions, and for such period of time as the Secretary of Labor may prescribe. Rule 7-A. Wages. Memorandum Circular No. 2, November 4, 1992. Section 1. Cash wage. The minimum wage rates prescribed in Section 1 hereof, shall be basic, cash wages without deducting therefrom whatever benefits, supplements or allowances, which the employees enjoy free of charge aside from the basic pay. An employer may provide subsidized meals and snacks to his employees, provided that the subsidy shall not be less than 30% of the fair and reasonable value of such facilities. In such case, the employer may deduct from the wages of the employees, not more than 70% of the value of the meals and snacks enjoyed by the employees, provided that such deduction is with the written authorization of the employees concerned. Section 2. Facilities. The term facilities, as used in this rule, shall include articles or services for the benefit of the employee or his family, but shall not include tools of the trade, or articles or services primarily for the benefit of the employer, or necessary to the conduct of the employer's business. Section 3. Value of facilities. The Secretary of Labor may from time to time fix in appropriate issuances the fair and reasonable value of board, lodging, and other facilities customarily furnished by an employer to his employees, both in agricultural and non-agricultural enterprises. The fair and reasonable value of facilities is hereby determined to be the cost of operation and maintenance, including adequate depreciation, plus reasonable allowance, but not more than 5.5% interest on the depreciated amount of capital invested by the employer. Provided that, if the total so computed, is more than the fair rental value, or the fair price of the commodities or facilities offered for sale, the fair rental value shall be the reasonable cost of the operation and maintenance. The rate of depreciation, and depreciated amount computed by the employer, shall be those arrived at under good accounting practices. The term good accounting practices shall not include accounting practices which have been rejected by the Bureau of Internal Revenue for income tax purposes. The term depreciations shall include obsolescence. Section 4. Acceptance of facilities. In order that the cost of facilities furnished by the employer may be charged against an employee, his acceptance of such facilities must be voluntary. Section 5. Payment by results. On petition of any interested party, or upon its initiative, the Department of Labor shall use all available devices, including the use of time and motion studies, and consultation with representatives of employers and workers' organizations, to determine whether the employees in any industry or enterprise are being compensated in accordance with the minimum wage requirements of this rule. B. The basis for the establishment of rates for piece, output or contract work, shall be the performance of an ordinary worker of minimum skill or ability. C. An ordinary worker of minimum skill or ability, is the average worker of the lowest producing group, representing 50% of the total number of employees, engaged in similar employment in a particular establishment, excluding learners, apprentices and handicapped workers employed therein. D. Where the output rates established by the employer do not conform with the standards prescribed herein, or with the rates prescribed by the Department of Labor in an appropriate order, the employees shall be entitled to the difference between the amount to which they are entitled to receive under such prescribed standards or rates, and that actually paid them by the employer. Section 6. Payment by results in government projects. In government projects, payment of wages by results, such as payment on PUCAO, task, or piecework basis, may be used by employers. Provided, however, that the output rates shall be in accordance with the standards prescribed in the immediately preceding section, whenever applicable, or with such rates as may be established by the Department of Labor. Rule 8. Payment of wages. Section 1. Manner of wage payment. As a general rule, wages shall be paid in legal tender, and the use of tokens, promissory notes, vouchers, coupons or any other form alleged to represent legal tender, is absolutely prohibited, even when expressly requested by the employee. Section 2. Payment by check. Payment of wages by bank checks, postal checks or money orders is allowed where such manner of wage payment is customary on the date of the effectivity of the code, where it is stipulated in a collective agreement, or where all of the following conditions are met. 1. There is a bank or other facility for encashment, within a radius of 1 kilometer from the workplace. 2. The employer, or any of his agents or representatives, does not receive any pecuniary benefit, directly or indirectly from the arrangement. 3. The employees are given reasonable time during banking hours, to withdraw their wages from the bank, which time shall be considered as compensable hours worked, if done during working hours. And 4. The payment by check, is with the written consent of the employees concerned, if there is no collective agreement authorizing the payment of wages by bank checks. Section 3. Time of payment. A. Wages shall be paid not less often than once every 2 weeks, or twice a month, at intervals not exceeding 16 days, unless payment cannot be made with such regularity due to force majeure, or circumstances beyond the employer's control, in which case, the employer shall pay the wages immediately after such force majeure or circumstances have ceased. B. In case of payment of wages by results, involving work which cannot be finished in 2 weeks, payment shall be made at intervals not exceeding 16 days, in proportion to the amount of work completed. Final settlement shall be made immediately upon completion of the work. Section 4. Place of payment. A. As a general rule, the place of payment shall be at, or near the place of undertaking. Payment in a place other than the workplace shall be permissible only under the following circumstances. 1. When payment cannot be effected at, or near the place of work, by reason of the deterioration of peace and order conditions, or by reason of actual or impending emergencies caused by fire, flood, epidemic, or other calamity, rendering payment thereat impossible. 2. When the employer provides free transportation to the employees back and forth. And 3. Under any other analogous circumstances, provided that the time spent by the employees in collecting their wages, shall be considered as compensable hours worked. B. No employer shall pay his employees, in any bar, night or day club, drinking establishment, massage clinic, dance hall, or other similar places, or in places where games are played with stakes of money or things representing money, except in the case of persons employed in said places. Section 5. Direct payment of wages. Payment of wages shall be made direct to the employee entitled thereto, except in the following cases. A. Where the employer is authorized in writing by the employee, to pay his wages to a member of his family. B. Where payment to another person of any part of the employee's wages, is authorized by existing law, including payments for the insurance premiums of the employee, and union dues where the right to check off has been recognized by the employer, in accordance with a collective agreement, or authorized in writing by the individual employees concerned. Or C. In case of death of the employee as provided to the succeeding section. Section 6. Wages of deceased employee. The payment of the wages of a deceased employee, shall be made to his heirs, without the necessity of intestate proceedings. When the heirs are of age, they shall execute an affidavit, attesting to their relationship to the deceased, and the fact that they are his heirs to the exclusion of all other persons. In case any of the heirs is a minor, such affidavit shall be executed in his behalf, by his natural guardian or next of kin. Upon presentation of the affidavit to the employer, he shall make payment to the heirs as representative of the Secretary of Labor. Section 7. Payment of, and other monetary claims in case of bankruptcy. In case of bankruptcy, or liquidation of the employer's business, the unpaid wages and other monetary claims of the employees, shall be given first preference, and shall be paid in full before the claims of government, and other creditors may be paid. Section 8. Attorney's fees. Attorney's fees in any judicial or administrative proceedings for the recovery of wages, shall not exceed 10% of the amount awarded. The fees may be deducted, from the total amount due the winning party. Section 9. Non-interference in disposal of wages. No employer shall limit, or otherwise interfere with the freedom of any employee to dispose of his wages, and no employer shall in any manner, oblige any of his employees to patronize any store, or avail of the services offered by any person. Section 10. Wage deduction. Deductions from the wages of the employees, may be made by the employer in any of the following cases. A. When the deductions are authorized by law, including deductions for the insurance premiums advanced by the employer in behalf of the employee, as well as union dues where the right to check off has been recognized by the employer, or authorized in writing by the individual employee himself. B. When the deductions are with the written authorization of the employees for payment to a third person, and the employer agrees to do so, provided that the latter does not receive any pecuniary benefit, directly or indirectly from the transaction. Section 11. Deductions for loss or damages. Where the employer is engaged in a trade, occupation or business, where the practice of making deductions, or requiring deposits is recognized, to answer for the reimbursement of loss or damage to tools, materials, or equipment supplied by the employer to the employer may make wage deductions, or require the employees to make deposits, from which deductions shall be made, subject to the following conditions. A. That the employee concerned, is clearly shown to be responsible for the loss of damage. B. That the employee is given reasonable opportunity, to show cause why deduction should not be made. C. That the amount of such deductions is fair and reasonable, and shall not exceed the actual loss or damage. And D. That the deduction from the wages of the employee, does not exceed 20% of the employee's wages in a week.